start the stream now.
At least we can put a name with a face the way we're situated.
That's right.
So we're good. Thank you for asking.
Hey, Matt.
Randy, how are you?
Good.
All right, Brandy, we are streamed. We are ready to go.
All right. I'd like to welcome everyone to the subcommittee meeting of the subcommittee to study the proposed adoption of a new comment to Rule 1.1, awareness of implicit bias and cultural differences. I need to remind all the subcommittee members of their duties under the State Government Ethics Act. Members of the subcommittee are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest in the appearance of a conflict, and are instructed to refrain from participating in any matter coming before this committee with respect to which there is a conflict of interest or appearance of conflict. Do any members know of any conflict at this point? All right. Seeing no hands waving, I assume there are none at this point anyway. Again, thank you all for participating. We appreciate you all being here. I know it's been an unusual year and a half or whatever. It seemed like 2 years maybe, but I guess it's just a year. But it's good to at least see the so many faces. Again, I guess the first thing we could do, I hope everyone has a copy of the minutes from our last meeting, the meeting of September 23rd. And I'll certainly entertain any motions that may be in order for that.
Move to approve the minutes.
Have a motion to approve the minutes. Is there a second?
Second.
All right, have a second. Any discussion? Hearing none, all those in favor of approving the minutes signify by saying aye.
Aye.
All opposed, like sign. All right, the minutes are approved. Let's go now to an update on the some of the pending bar initiatives related to this area.
Great, thank you, Brandy. I feel like I would be foolish not to point out that we're actually joined by another member, at least another member that I think is potentially here at this meeting. Judge Dunstan is on maternity leave because she just welcomed Isaiah into this world.
Right.
So congratulations, Judge Dunstan. Understand that he may be talking as well, and we welcome Isaiah's input. But nevertheless, we have a couple of different initiatives that are ongoing, as you all know, with the State Bar. And just wanted to provide you a quick update to the extent that you have been interested about some of the activities that have occurred during this quarter in between the January and April meeting. The two initiatives that are also ongoing, the study of anti-discrimination language in the rules of professional conduct, which includes an inquiry about the preamble. As you all remember, the preamble, there was a proposal for an amendment to the preamble that was published in July of 2020. And after the publication period, we received a great deal of feedback, and that preamble proposal was sent to subcommittee for further study in light of the comments. That subcommittee just met last week, and after looking at the comments, they decided to amend their proposal or at least I should say amend or recommend a new amendment to the preamble. And I'm going to share that language. This language, just to be clear, is something that has been voted upon by the subcommittee and has been recommended for publication. It will be going to the Ethics Committee this next quarterly meeting and to the Council for publication. But this was the language that the subcommittee settled upon and thought that this was more appropriate for a proposed preamble amendment. You can see here the proposal would state, the North Carolina Constitution requires that right and justice shall be administered without favor, denial, or delay. Public confidence in the justice system is strengthened when all participants are treated equally, fairly, honestly, and respectfully within the system. A lawyer, as a representative of and crucial contributor to the justice system, should foster public confidence in the administration of justice by treating all persons they encounter in their professional capacity equally, courteously, respectfully, and with dignity, regardless of a person's race, sex, national origin, religion, age, disability, sexual orientation, gender identity, marital status, or socioeconomic status. So this is, again, this language was reviewed and ultimately voted on for and created, made a recommendation to the Ethics Committee for publication as an amendment to the preamble, essentially substituting for the prior proposal that had been published last July. So that is ongoing. As far as the study of the actual text or a change to the rules of professional conduct, as far as including anti-discrimination language in the text, I think that subcommittee is very much, they're still working on it. They're still studying the matter, but they're very much, interested in seeing the outcome of the case that's in Pennsylvania. Since we last met, the Pennsylvania State Bars, I think I may have referenced this in the last meeting, but the Pennsylvania State Bar had adopted anti-discrimination language into their rules of professional conduct. They were sued in August, and in December of last year, a federal judge from the Eastern District of Pennsylvania essentially determined that the new anti-discrimination language in the Pennsylvania rules of professional conduct was unconstitutional. The judge found that it violated the First Amendment. That ruling, or essentially I should just kind of recap that and say that the judge issued an injunction preventing the State Bar from enforcing that language. That ruling has been appealed to the Third Circuit now. So that is before the Third Circuit. Briefs aren't due until, I think the first brief is due middle of March. So it's still going to be some time before we get any sort of determination from the Third Circuit, but that subcommittee is interested in what happens there. And certainly I will be keeping you all updated on that as well. But that's where that subcommittee stands. The other initiative that you all, I'm sure, are aware of, the CLE board recommended I guess it was late last year in October, a change or a new category of CLE to be required on whether it's a yearly basis or what frequency is still kind of to be determined. But the CLE board recommended that attorneys be required to take diversity or CLE on diversity inclusion issues. And that, of course, was published in October. That rule received a lot of comment too. So the rule was sent back by the council to the CLE board in light of the comments, or to review the comments. And the CLE board also met last week, and they concluded that that their opinion or their position on the new category of CLE should still stand. So they're sending it back to the State Bar Council for the April meeting with the recommendation, essentially that that their prior recommendation that this is an appropriate category for new CLE should stand, and that this rule should be adopted. So that's the update on those other initiatives. That brings us to really to what we are doing here. And Brandy, if I guess maybe I'll pause before we get into what we're talking about to see if there's any questions about these other initiatives.
Oil, Jordan.
Yeah.
How about getting a message? Tell him that I'll.
Oh, Darren, was it? Oh, sorry. Anybody have any questions? Okay.
Yeah, this will
none.
definitely be more of a discussion-oriented meeting than our last one. Our last one was a little bit more educational, perhaps. So we look. I don't want anybody to think because it's a Zoom meeting or whatever that we don't have enough time for everyone to say what they need to say. So feel free to jump in. Okay.
All right. Well, Brandy, if it's all right with you, I'll go just do our recap of what we are approaching. Right. Of course, you all know we are here talking about a potential new comment to Rule 1.1 on competency. At our last meeting, we talked about kind of how we were going to proceed, starting off with education, understanding what is implicit bias. And that was where Professor Jim Drennan from the School of Government offered a presentation on implicit bias. And really kind of this, I guess I don't want to butcher everything that he very intelligently said, but you know, essentially kind of I think he described it as that we're all carrying baggage. We just may not realize that we're carrying something to every single situation. And so he provided that education on the topic. And today we want to talk about the role of comments, because the proposal here, and again, I'm going to share my screen. The proposal, this was initially introduced at the ethics committee meeting last summer. But it's looking at whether or not there should be a comment to Rule 1.1 that essentially states that a lawyer's competency encompasses a lawyer's awareness of cultural differences that could exist between lawyer and client, or perhaps between client and those that are involved in a legal matter. It also includes a lawyer's awareness of implicit bias and how implicit bias can impact a client's case and ultimately the lawyer's representation of that client. This language goes on to say that a lawyer should be educated regarding such potential differences and bias to ensure understanding of the client's needs, effective communication with the clients and others, and adequate representation of the client. This is largely aspirational. It's encouraging language. It is to some extent similar to a comment that we have, comment 8 under Rule 1.1, that says that a lawyer has a duty to maintain their competency, and part of that competency maintenance includes being aware of the impact of technology on the practice of law. And from that, of course, we've seen there's a technology CLE now that lawyers are required to attend because of the significant impact technology has, not just on our practice, but also our clients' lives. So that's the proposal here for our discussion today. Like I said, we want to talk about the comments, just what role do the comments play in the rules of professional conduct. Just as a quick side note, as we're looking at this screen, you'll see this stuff was in your materials, and particularly I'm on page 32 of 40 in the PDF. There's some alternative language here that I drafted, and this is really just trying to serve as a springboard for discussion. The alternative language is broader. I think the alternative language, and we can get into discussion of the different proposals a little later on, but just so you know, this is kind of the first time that I have shared this alternative language, but just kind of looking at the original proposal and trying to see where conversations and other subcommittees have gone. I thought that it may be worthwhile to provide another take on this that is a little bit broader, that really kind of focuses on a lawyer's need to be aware of a variety of factors, which may include cultural differences and implicit bias. But of course, there are a lot of different factors that play into a lawyer's competency in being able to understand and provide the most effective representation to the client that goes beyond just perhaps legal knowledge. So that is in your materials. But at this point, I think this is when we wanted to talk about the role of comments and really an overview of Rule 1.1. So we're all on the same page and we can start engaging in this discussion. I think just spoken with Brandy before this meeting, and we were I mentioned that I think there's kind of a couple of questions that are up for your discussion today. One, do we think implicit bias and cultural differences should be a part of lawyer competency? Two, should that, if we answered yes to that, should that answer be reflected in the rules of professional conduct via the comments to Rule 1.1? And three, if the answer to both of those questions is yes, what exactly should we put into the comments? So I guess as a quick statement, like we said, we're talking about the comments to Rule 1.1. Carmen Bannon is here too. And I don't know if Carmen, I know I mentioned that it might be helpful to hear from the Office of Counsel, that perspective, the disciplinary prosecution perspective about the role of comments in your own work, in your investigation and prosecution of claims of misconduct. So Carmen, do you have any thoughts that you'd like to share about just kind of how you react to comments?
Yes, and I apologize. My dog has decided she has some thoughts to share too. Hush. Sure, I can speak to that a little bit. When we are evaluating whether or not conduct by a lawyer is a violation of the rules, we will not ever rely solely on the content of a comment to the rule. The rule is the black letter law. The commentary is designed, I think, really to help lawyers see how the black letter law may be applied. And that's how we treat it also. So I think usually the comments really don't expand upon what is stated in the rule itself, but to the extent they might appear to cover more conduct, say, than the rule itself, that's not something we would pursue as a disciplinary matter. I'm not going to stand up in the DHC and say this lawyer has violated the following comment. That said, the comments are sometimes very useful in that we are charged with arguing to the DHC how the rules should be interpreted. And if there just happens to be a comment that concurs with the Office of Counsel's argument about how the rules should be interpreted, that certainly strengthens our position. So I think the comments are not central to the disciplinary process, but they're definitely informative, both for the bar at large and for the way we interpret the rules in our office. Does that answer your question, Brian?
Yes, that was, yes, thank you.
Okay.
And I think, to that end, I just going back to the materials, the agenda that I had provided, I included the scope of, or that's found in the rules of professional conduct as part of the agenda materials. I'm going to share this particular section. This is the last page of the PDF. You can see here in point 8 for the scope, the comment accompanying each rule explains and illustrates the meaning and purpose of the rule. The preamble and this note on scope provide general orientation. The comments are intended as guides to interpretation, but the text of each rule is authoritative. And that really is what Carmen was referring to there, that the comments offer this guidance and understanding of interpreting exactly what the rule is meant to cover, what the rule is meant to address, but the text of the rule is authoritative. So that's just to kind of, again, provide the framework here. And I think that also lends to the general understanding, or maybe just kind of a quick point on something that may be in your heads. If you all participated in or perhaps observed the other subcommittee dealing with the anti-discrimination rules, or the language, potential anti-discrimination language that could go in the rules of professional conduct, we engaged in an entire subcommittee meeting, including a presentation that Carmen and I put on concerning the constitutional aspects of some type of language in the rules of professional conduct that would prohibit certain conduct. Or at least declare misconduct, or as misconduct, certain types of conduct, certain types of discriminatory conduct. And those concerns aren't necessarily applicable to the comments that we're talking about, particularly a comment that is stating really kind of an aspirational sort of statement of what should competency encompass. Depending on the language that we use here, it's one thing if you have a comment, and just by way of example, thinking of some other jurisdictions that have addressed anti-discrimination language or discriminatory acts via their comments. There are some states that have expanded the definition, or maybe more explicitly stated that the scope of Rule 8.4D, which says that it's misconduct to engage in prejudicial or conduct that's prejudicial to the administration of justice, that they have comments that say that particular rule encompasses discriminatory acts on these different grounds. That would be something that I think, is where an example of where a comment is really being kind of incorporated into the rule for potential enforcement purposes. But I think in this situation, at least as the proposal is stated, and perhaps depending on our discussion here, I don't think we're facing the same sort of situation as far as trying to, I guess, create an enforceability standard for what competency truly is for purposes of any sort of disciplinary prosecution. So that's why we're not really spending a great deal of time getting into constitutional considerations like potential viewpoint discrimination or First Amendment concerns or things of that nature. Because the proposal, as stated, is really more aspirational, encouraging lawyers to be educated on these topics. But of course, if anybody has questions or concerns about that, again, like Brandy said, this is meant to be a discussion this meeting. So by all means, raise your hand and we can talk about those things. But that's the, I guess, kind of starting off. And Brandy, I'll kind of look to you for how we start this discussion. I included the entirety of Rule 1.1 in your materials as well. So hopefully you've read through that. I know sometimes 1.1 is just kind of, well, it's the competency rule, but to read through the entirety of the rule as well as the comments to give an idea of what context we're dealing with regards to this proposal, hopefully was helpful. But we are, I think, at this point, Brandy, we can just kind of start talking about those questions. Do we think competency should be stated to encompass this idea of, the competency requires or encompasses a lawyer's awareness of implicit bias and cultural differences and things of that nature, and just kind of go from there.
Right. Let me ask one thing, Brian. If the case that's currently out of Pennsylvania, if it goes against the Pennsylvania bar all the way up, would it make any difference, even if they said that their rule was too onerous or not appropriate or whatever? We could still do something with a comment, couldn't we? Is that kind of what you're saying now? If we
Yes.
felt it was an aspirational goal that we wanted to go forward with?
Yes, I think that is all dependent upon what gets adopted to some extent, but really based upon the proposal as it currently stands, I don't see the Pennsylvania case really providing any sort of directive on this proposal. I think it certainly would. Let's say if the Third Circuit upholds the injunction, and if they go to the Supreme Court and the Supreme Court agrees, then I think that would very much impact the subcommittee on anti-discrimination language and the text of the rules.
Right.
But this one, I think, based upon how it's drafted, again, it's talking about what a lawyer should do as opposed to what a lawyer shall do. And I think there's.
Brian, I would go a step further and say that the basis for the injunction of the Pennsylvania rule is because it is a state restriction on free speech. And this a comment to the rules of professional conduct in general doesn't constitute a restriction. And particularly in a case like this, where it is phrased in the affirmative, it's not a proscriptive statement. It's a recommendation. So there's really no way to construe this as similar to what's going on in Pennsylvania at all.
Brian, if I can ask, in both the proposed language and the alternative language, it talks about a lawyer should be educated, and then something else. It talks about education in both. Is it required that the CLE portion of this also pass for our comment? Can one stand by itself without the other is my question, I guess.
Yes, I think they can. I don't think this is dependent upon the CLE component. The CLE component, frankly, the board, the CLE board is moving at its own pace and under its own determination. I think early on they discussed this proposal and kind of noted that they felt that it made sense based upon what they felt was appropriate for CLE or for their recommendation on including diversity and inclusion CLEs as a required category, but that they didn't feel it was necessary. So this is, these things, while related, are still can be treated separately, and I think should be treated separately.
Did everyone get a chance to see the proposed language, both the original one as well as Brian's most recent? I mean, I know he just showed
I
it.
did, and I have a question, Brian. Somewhere,
Okay.
and I was reading it online, so I couldn't highlight it like I ordinarily do, or I'm not sophisticated enough to know how to do that. But I recall seeing something that was, I thought, in the scope section about distinguishing between competency and something that would be enforceable. And it sort of brought back to mind what Professor Drennan was saying about it makes sense to say that this is what we want to do, and that is to address how lawyers should treat other people. But then as I listened to him and reflected upon what he had to say, as well as read this proposal language, I could not help but to think that it's a question of changing someone's heart. And we can't necessarily do that, but we can put something in place that calls attention to the fact that if a person is dark of heart, that it doesn't have a place in the proceedings, and that we aspire to be different from that. And this comment, I think, fairly puts that out there for anyone to see, so that we would not get into the business of enforcing people for being obnoxious, just like we don't now, or perhaps being rude, even though we say that's unprofessional conduct, perhaps, and there's some rules that more specifically address that. But I'm hesitant to put too much rigidity into what we develop, lest we find ourselves, as the comment said, using it as a weapon in litigation or retaliation.
No,
That's
Judge,
my
and I think that's wise, Judge. That this, and that's kind of to the point of the proposal is drafted. I think really what Carmen, or how Carmen described it, that it is a positive statement. It is not a restriction. It is not something that I can in any way reasonably see being weaponized, especially in any sort of disciplinary context. It is, and I think this is, it is akin to some of the principles that we see in the preamble, the way that the preamble sets out this general orientation for not just the rules of professional conduct, but lawyers' responsibilities, the duties, the aspirational calling that we have. I guess duties is probably a wrong word, but it's really just kind of the I guess like I said, the aspirational calling, the ideals that our profession wants to embrace. Things like if this proposal that the subcommittee recommended passed, would be to treat everybody respectfully, equally, with dignity, regardless of their personal characteristics. Similar provisions in the preamble talk about pro bono representation, how we should, as lawyers, offer pro bono services and seek to assist or step into civic leadership roles. This comment, I don't think it's necessarily a preamble comment, because it has a kind of the aspirational, I think an aspirational tone to it, and really an aspirational construction. But it is something that I think is just, in terms of appropriately placing the language for lawyers to understand, what does competency really mean? You can see in the actual rule there that competency talks about legal knowledge and skill, thoroughness, preparation. And I think, when you go on into the comments, I mentioned before, comment 8 talks about maintaining competence. To maintain requisite knowledge and skill, a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with technology relevant to the lawyer's practice. And I think that is another example of where in the comments we just recognize that competency, yes, it requires knowledge of the legal matter at issue, and a developed skill set, but that under this proposal, this kind of, the proposal recognizes that there are multiple factors that are at play when it comes to representing a client and effectively representing a client. Implicit bias can detrimentally impact a representation or a client's case. And it's something that I guess the question to this committee is, do you all feel that competency should be kind of formally set out as encompassing that very idea? Marcy, I see you have your hand up.
Yes, so would it just be added in the comments as a number 11? Is that what you're saying? Because I don't see where it really falls under legal knowledge and skill. You know what I'm saying? Is it a category all by itself?
I think that would be for discussion. I envision it being either at the end of the comments, like you said, as an 11. Potentially, it could go into something maybe perhaps after either after number 8, maintaining competence, or even thoroughness and preparation. But I think that's kind of the placement of the actual thought within the predefined categories of the comments is something that we can discuss of what we think is most appropriate if we feel that this comment should even be included.
I believe Stewart has her hand up also.
Thank you, Brandy. So that was going to be my comment or my suggestion. I think it would fit well under the comment that was added to reference technology when that amendment was made. That's comment 8 under maintaining competence. And, my thought as we were going through all of this is that we've just been down this road with the technology requirement. And I see that this would fit nicely, I believe, into that same framework, because just like with technology, if you don't know, you don't know. If you're not familiar with technology, you don't know what you don't know and what you're missing. Same with implicit bias. You could be very well intentioned and not somebody, who is overtly biased in your opinion, but not realize what you're missing here. And so I think that this, in my opinion, lends itself well to just following that same type of path that the technology requirement followed, and adding a comment in there under maintaining competence that even mirrors that same language, which I think the first proposed language for the new comment did. I think that the alternative language is a little bit softer, I guess. And we can discuss which we prefer, but that just strikes me as a good path for us to take. I do believe that this is an issue of competence and it should be included in the comments.
Let me ask if anyone has a dissenting view they'd like to share, whether it's theirs or someone else's that you've heard from. I mean, I think everything I've heard so far seems to be that we're in favor of a comment. And I guess if that's the case, then maybe we need to be talking more about specific language. And I know first we got to decide, do we think this is a appropriate action? And I haven't heard anything negative towards that yet.
If I may, Brian, refresh my memory on if, I guess, procedure. If we accept or extend, let's just for example, proposed language number 1, we take it on to ethics. Ethics takes it to council and it's published as any other method, correct?
That's correct. And we had I guess I want to bring to everyone's attention that, this particular proposal was introduced last summer. We did receive some, it's never been voted upon, but we did receive some comment during the preamble publication where folks said that they expressed their opposition to adopting any comment to Rule 1.1 as proposed, but they didn't address the substance of their comments was really focused on a rule of professional conduct. It was not focused on this particular comment. So we have not really received any substantive comment on this particular proposal at this time. But yes, Matt, you got it exactly right. This would be a recommendation. We are a subcommittee of the Ethics Committee, so the recommendation from this subcommittee would go to the Ethics Committee, and subsequently Ethics Committee, if they voted to recommend it for publication, goes to the council and published just like everything else. Stu, did you have your hand up again, or is it okay? I'm going to lower your hand. Thank you.
All right.
Sorry.
But I think Stuart has led us to a place where we can enter into discussion of whatever it is that we decide today. I like what she suggested.
So is that a motion that we adopt I guess Brian's alternate proposal? Is that the way when you were referring to, Stuart?
Well, no, I don't know that I'm there yet.
Okay, okay.
But no, it was more of it was more of just a comment in response to Marcy's question or comment about where would we put this? How does it fit in with the comments rule 1.1? Because I had that exact same question, and I pulled up while Brian was talking rule 1.1 and kind of read through the comments, and I saw where I assumed the ethics committee had put the comment on technology under maintaining competence, and I just thought that that seemed very appropriate. So when we do settle on some language, and I think we should certainly discuss the two proposals that are on the table. I think that would be where I would propose or move that it would be inserted in the comments under that same heading.
I think, Brandy, just to make sure that we're all on the same page, I think your last question had just been, it sounds like everybody has positive feelings towards the idea that competency should be stated or a comment is appropriate on this topic. Just what exactly that comment is really to be determined. But I think you would call for anybody who had any concerns or dissenting views, because again, this is supposed to be a candid discussion. Unfortunately, I think these discussions always occur better in person.
Oh, yeah.
But certainly we want to have as candid of a discussion as possible if anybody has different feelings.
Brian, I'll make a motion, or Brandy, I'll make a motion that we move forward with a comment to Rule 1.1 to include the type of language regarding biases or something along those lines.
Okay. Is there a second to Judge Dunstan's motion? Again, this is just
Second.
whether we're going to do one. Okay, we got a second. Any further discussion on that? All right, all in favor of Judge Dunstan's motion that we proceed with a comment, whatever that might be, signify by saying aye or raise your hand.
Aye.
Aye.
All opposed, like sign. Okay, we're making progress.
All right.
Now-
Well, then I guess the discussion again, we have two proposals that are on the table. I want to be very clear that if you all think that there is something completely different that should be said, that will not be offensive in any way. I drafted these things, kind of the best that I could, what I thought was appropriate for what we're talking about, but I know that they are likely imperfect. So as Stuart referenced, just to her point, I think she kind of hit the nail on the head. That the first one was the original proposal. It's a bit more direct. The second one is softer and trying to encompass perhaps a broader view of just what competency should include, and kind of recognizing that implicit bias and cultural differences are perhaps some significant factors that lawyers should be aware of, but that there may be other factors as well. And you can see there, I included some language in there about Rule 2.1, because that's a rule that I think we often skip over. We have a responsibility as an advisor to advise clients not just on the legal aspects of their case, but perhaps there may be other factors, economic, social, political factors, things of that nature that could impact the representation and the client's outcomes, or excuse me, the goals of the representation. So that language, is there for your discussion. I don't know if anybody likes one or the other, or some variation thereof, or something completely different. But I think the floor is open to discuss that now.
Stuart?
Okay, I personally prefer the original proposed language with some modification. I think it more closely mirrors the language on technology, and that is the reason that I think it's helpful. The alternative language uses may in some places that I think makes it confusing to follow. So you're like, do I need to do this or do I not need to do this? And as a practitioner. And so my only comment on the original proposed language is that I'm not sure why awareness of potential cultural differences is in there. I almost feel like I would omit that portion so that it reads, competent handling of a particular matter includes a lawyer's awareness of implicit bias relative to the client or anyone involved in the client's matter that might adversely affect the lawyer's representation of the client. A lawyer should be educated regarding such bias to ensure, or such implicit bias even, to ensure understanding of the client's needs, effective communication with the client and others, and adequate representation of the client. I feel like that more closely mirrors the technology language and is a clear directive to the bar.
All right. See,
I'm
With
trying
Judge-
to, I'm sorry, I'm trying to do a track changes version real quick so I can put that on
Gotcha.
the screen to show what Stuart had just proposed.
Okay, I see Judge Johnston has her hand up.
So I would say that I definitely agree with Stuart, especially with I like the first language. I just feel like it's a little bit more direct. No offense, Brian, you're so eloquent. But I also like what you said. The only thing I would add is I still like cultural awareness in that. So I would leave everything the same like Stuart just said. But then I would keep in that cultural awareness just because I feel like, I don't know, I think about times that as a judge, I've had individuals from, let's say, a Middle Eastern background. And it's important for me as a judge to understand that cultural awareness. So that way, whenever I'm making my ruling, I'm not making it from the same perspective as an American, but I'm understanding the context of, what they believe, the role of the woman in the home, those kind of things, and just kind of looking at that holistically and understanding that and being open and aware of that, of being educated on that while that attorney is providing that information to me, so that I'm not just looking at it from only my lens as an American, but also understanding that. So I feel like cultural awareness is also key. That language is key as well. So that's the only thing I would add to that.
So Judge, you're saying you like it the way it is. I mean, the language that currently has.
Oh, no. I like what Stuart did, what she inserted in, but she left out, I think, Brian, if you could pull it up.
Yeah. What?
Yeah,
And
so-
Stuart, I may not have exactly what Stuart had said then when I was trying to fuddle around with Microsoft Word. So Stuart, tell me what have I missed in your amendment?
I think that's it exactly. So I didn't add anything except for maybe the word implicit there before bias in the third from last sentence.
Yes.
But yeah, mine was to take out, and I guess I appreciate Judge Dunstan your point, and that makes sense to me. I guess the reason that I took it out in my mind was because there's so much that can go into implicit bias other than just cultural differences. And so I was wondering if by saying cultural differences we're implying that other things don't need to be considered, not listing those things, that they're not included, which is why I just kept it more general at implicit bias. But really I'm fine with the language as is, or with the change that I proposed. I just prefer the wording of the original proposal to the alternative because I think it's clearer.
Yes, and my suggestion was, so it would say exactly what Stuart says. So competent handling of a particular matter includes a lawyer's awareness of, taking that part out, where it says, so awareness of implicit bias. And at the bottom down here, you had said, I'm sorry, the very bottom in your alternative language where she pulled it from, you said and cultural differences. So that was the only thing I wanted added back in, if that makes sense. So it would say implicit bias, because I love what you said there, and cultural differences relative to the client or anyone involved in the client's matter that may adversely affect the lawyer's representation of the client. That was the only part that I was changing, I guess, if that makes sense, or adding to. But I agree with Stuart with everything. That was the only thing I just kind of wanted I like that in cultural differences as well, in addition to implicit bias. But I I didn't mind it being taken out at the beginning where it says potential cultural differences. Does that make sense? So that's
Yes, I
exactly it
see
right
what you're
there.
saying.
Yeah,
Yeah.
that's it.
I agree.
Any other comments? The Takia, you had your hand up at one point, I hope. You're
Yeah, I
muted.
did. I was just gonna say that I agreed with Stewart and also Judge Johnson. I like the first language. It was more direct. It didn't seem as fluffy as the second, the alternative language. And I think it should be direct. It should say exactly what we wanted, what we mean for it to say. And I think the first comment does.
Any other comments?
If I can ask a quick clarification, so this second sentence, since we've taken out, or I guess we have a proposal here of saying, from the first sentence, competency includes the lawyer's awareness of implicit bias and cultural differences relative to the client. Second sentence, a lawyer should be educated regarding implicit bias. Should it be such cultural, or I guess, should it be regarding potential differences regarding cultural differences and implicit bias, or implicit bias and cultural differences? I guess just a reference to these cultural differences in the second sentence that has been removed per the, I guess, Stewart's first comments, but we haven't necessarily included it back in if we're going to include it in the first sentence. So what do you all, how do you all feel about including that? About a lawyer's need, or maybe just a lawyer should be educated regarding cultural differences?
It seems kind of like we just flip cultural differences and implicit bias.
The way I read it, we just kind of, I agree with Brandy, we just flipped them, bias versus, differences then bias, and now we've just said bias and differences.
Mm-hmm.
So I've just included this language. A lawyer should be educated regarding implicit bias and cultural differences to ensure understanding of the client's needs, et cetera. I think that way it ties both in. You should be aware of it and you should be educated on it. So is that acceptable? Is that what we're talking about here?
I like it.
Brian,
Yes.
let's go. I couldn't figure out how to get my hand raised in this screen, but it's not unusual. But
Come on, Boomer.
Bruce, that hurts coming from you. Should we use the word educated or should we use the word aware? I mean, educated sort of seems to imply that we need to be trained about this, and is that opening up an issue that may cause us difficulties, or should we just be aware, or some word reflecting awareness as opposed to education?
That goes, Colin better stated my question from earlier. Does this stand by itself without the CLE component? If the CLE component doesn't pass and we use the word educated, I have some heartburn about that as well.
We still say should. I mean, should is, again, we're talking aspirational with comments in general, aren't we?
Yeah, and I see what you're saying. It's almost like when you're saying somebody should be educated, is that essentially putting some sort of directive on, or could it be interpreted as not? And I don't think that's what we're trying to say at all. But could it be interpreted as lawyers should go and receive training and take a particular class, when we are trying to say a lawyer should be aware of these ideas, and perhaps that is the better choice of word, because I think that's ultimately what the comment is saying, that it's about a lawyer's awareness to provide competent representation. The sentence says that really a lawyer should be educated, and I think that does kind of imply should educate him or herself on these topics to the extent that they are unaware. But I think that's a great comment and something for our discussion. Marcy, I see you have your hand up.
Right.
Oh, sorry, Colin.
I was going to say, right now I have a federal appointed client who is from Myanmar and a refugee, and I don't know how to get educated. I mean, I can talk to people and try to learn and develop a sensitivity to dealing with his situation. I don't know how I can educate myself other than just talking to folks.
Right.
So are you asking the question of whether the lawyer should make effort to become educated, or whether we should indicate in this comment that we're not pushing, but we think that a lawyer should be educated, as though the education component or CLE component will be mandatory? I'm not sure I'm following the direction of the discussion.
Well, I'm highlighting, and Colin, tell me if this is what if this would kind of address what you're talking about. If we put a lawyer should be aware of implicit bias and cultural differences to ensure understanding. Is that what you're getting at?
Yeah, that's sort of what I was doing. The saying someone needs to be educated about it seems to me that we're adding something. I just think that may be if we're going to get pushback and problems. And what we want is to people to know that there are differences, and we want them to be sensitive to those differences. How they learn about them is not the issue, other than the awareness.
Okay.
Randy?
Marcy, I think Marcy and then Judge Dunstan.
Right.
Thank you, Colin, because I've been sitting here thinking of what about this was bothering me, and that's exactly it. We don't need to have unintended consequences where lawyers are afraid to take cases for people that are different than we are from a different country, because we are afraid that we could get in trouble if we don't understand everything that's different about their culture. So I like the word aware of better. I think we should be aware of and make every effort we can to be aware of implicit bias and cultural differences. You don't want to scare lawyers away from representing somebody that's different because we, could get in trouble if we don't understand all. Does that make any sense? What I'm saying?
Right. Oh, I understand. Yeah.
Yes.
So I think, Colin, you hit on something that's just, I've been sitting here, I've been bothered by it, but I couldn't quite figure out why. I think this is much better.
Okay. And Judge Dunstan?
Well, I was going to say, I also agree. I think a lot of times it's hard to, you can educate on implicit bias. You can put that in a PowerPoint. Sometimes it's a lot harder to educate on cultural differences in a way, because I think when we hear the word educate, and I think Judge Hannett, this kind of goes to your question, when we talk about educate, we typically think of some type of classroom, or we think about a CLE, or we think about something along those lines. And, really, I think aware of really opens up an avenue where it can be just, like Colin said, just getting to know the person, listening to them. That's not necessarily you're educating yourself, sure, but it's not in the strict way that someone reading this might say, okay, educated, okay, I need to find a CLE on cultural differences of the type of client that I'm dealing with. So I think I also agree with aware of. I think, and I was going to say, if we wanted to say, I think the language is fine, but really, we could just say, this is to ensure understanding of the client's needs, effective communication, if you want to take out that whole first part again, since we already said it before. But I'm fine with the second sentence if it's very much like how, the technology one was. But I think that this really makes clear what we're trying to do here without trying to pigeonhole someone into a CLE or something like that for this proposal or for this comment.
Sorry, I had myself on mute. What do you all think of, this is something that our esteemed executive director just suggested to me. A lawyer should be aware, or should be cognizant of the impact of implicit bias and cultural differences to ensure understanding of the client's needs, effective communication, and adequate representation. I think that's kind of what we're talking about here. It's being aware, it's being cognizant of the impact that these things can have on a particular representation.
Well, does that sound like then it's going back to the first sentence of the alternative language, which refers to competent handling may include, that you could say competency includes awareness of the impact and whatever we have here in the second sentence, so that instead of putting the burden of a lawyer to do something, a lawyer should do these things, then competency includes, so that the lawyer kind of gets it there. Well, if I mean to be competent, then I need to do these things that are listed in this sentence.
Yeah, I think the
so it makes it more of an active sentence as opposed to an aspiration. It's declaring competency includes.
My concern is that we have two sentences that sound very similar back to back, that it'd be competent handling of a particular matter includes these things, and then competency includes implicit or awareness of. I mean, we could essentially just go with the one sentence instead, perhaps, but that's I guess that's where the aspirational of a lawyer should do this, or yeah, they should be cognizant of the impact of these things. That is the aspiration there.
Hey, I don't know what folks think, but is handling of a particular matter, is that important? I'm not sure what that's adding.
I agree. I think you could almost just survive with the second sentence as, something to the effect, as part of competence, comma, a lawyer should be cognizant, etc.
All right, I'm gonna rather than watching me amend everything, I'm gonna go ahead and do it and come back to you all with something there. So we're talking about essentially a single statement as part of competency. A lawyer should be cognizant of the impact. Here, let me see if I can share this one.
Should be aware of, and then the impact of their awareness. Is that where we left it?
Well, this is what I think I just heard. If we just wanted a standalone comment that simply said, as part of competency, a lawyer should be cognizant of the impact of implicit bias and cultural differences to ensure understanding of the client's needs, effective communication with the client and others, and adequate representation of the client. Is that what we were just referring to?
Why is cognizant of better than aware? I don't understand. What was the difference?
I think we could go back to aware, because I was just using a synonym there since we had aware in the prior sentence. And again, I don't know if this is where we do not even care for this language, the impact of. If we were just going with a single statement, it could just be, as part of competency, a lawyer should be aware of implicit bias and cultural differences.
I'm not opposed to aware of versus cognizant. I think I agree with Brian's comment a little bit ago that we seem to have two sentences that, 6 of one, half dozen of the other seem to be saying.
I
It's
agree.
much more concise.
I agree. I just think the only thing I like about the second sentence is the fact that it actually lays out what it means. Like what this is: to ensure the understanding of the client's needs, effective communication with the client, others, and adequate representation of the client. I mean, obviously that's, to me, kind of, it's redundant, but at the same time, I'm like, what attorneys could really need, what attorneys really need that? And I feel like there probably are some. It's just what do we want that, like, you know, do we need it? Number one, I guess. And then number two, I mean, do we just, you know, just say it? And this is to ensure understanding of the client's needs, effective communication with the client, others, and adequate representation of the client. I mean, is there
So
one way?
add it as a more of a compound sentence as a second sentence.
Right. Like, you know, however we could do that. You know, like I said, involved in the client's matter that may adversely affect the lawyer's representation of the client. This is to ensure understanding of the client's needs, effective communication of the client with blah, blah, blah. Sorry, I can't see it because of my, there we go. Communication with the client, others, and adequate representation of the client. I mean, my suggestion would be either one quick sentence or two quick sentences. I don't know if we need a lawyer should be again. If that makes sense. Like, I don't think we need to say implicit bias and impact of implicit bias and cultural differences. I don't think we need to say that again. I just think we just need to include that part, the to ensure. And then we're just
This is what you're proposing, Judge?
Yes.
On the screen?
Yes.
Yeah,
Works
I'll
for
just,
me.
oh, go ahead. Go ahead, Judge.
I was saying it works for me. It seems more concise, and I don't have a problem with it.
Colin and Marcy and Matt, I know you all have had some thoughts here. What do you think of this? Is this addressing the concerns that you had previously, maybe the questions about certain or the previous version's language?
Yeah, my big thing was the education side of using the word educated. And I may be thinking too much about who's pitching the ninth, but are we putting this, the preamble, I know the preamble's kind of already hanging out there, but the preamble, as well as any potential other, are we putting that in front of council at the same time, or is it coming piecemeal? I guess I'm trying to look at this from, you know, the rank and file members of the bar, when they see this, is it going to be all of this at the same time, or is it piece? I'm struggling with that. How, and that may be a better question because it's probably going to fall in Darren's lap or Marcy's lap.
This, as it stands right now, at the April meeting, the council will very likely, and I don't want to speak for the ethics committee, I don't know what they're going to do, but I would imagine that the council will be presented with a recommendation for publication of the preamble amendment, but then the CLE proposal was previously published and nothing has changed. So that is not necessarily up for publication again. I think the procedurally that would be up for adoption by the council, okay, with, of course, it going to the Supreme Court for final approval. So that's where those things are at. But those two things would be before the council, just kind of with different outcomes at the April meeting. Okay. And this would join in if this committee reaches agreement on language and makes a recommendation for some sort of language to be published, then this would basically join the same pathway as the preamble proposal.
I'm fine with it. Your question, Brian. It's good with me.
Okay. Alice.
So you all could also make a recommendation in that regard. I mean, there would be nothing wrong with that, to recommend that they go forward altogether, or to recommend that this comment on competency be published for comment, and that the CLE rule adding the requirement be held back so that they would both become effective at the same time, or that at least lawyers could comment on them both because they're related to each other. That would be perfectly fine to make that recommendation, and then the council could consider that as well. I don't know what is the preferred route, but it's not just because our process is a certain way doesn't mean that the council doesn't have the authority to say, no, we're going to hold back on sending this to the court or adopting it to send to the court until we've looked at this other issue.
What did we do on technology? Didn't we do both at the same time? The comment and the CLE rule?
I'm trying to remember. I think we did. I think we did. No, actually, I think the comment came first,
Okay.
Matt, because the comment was in response to the ABA amending the comment to ABA Model Rule 1.1. And then the CLE board, almost sort of independently, but I think it was after that had been done, said, you know, we really ought to have a mandatory requirement in this area.
Well, and I guess I'm thinking about presentation, as I said, to the rank and file so that they understand, is it, and I don't know what the answer is it better to do it this piece, then this piece, then this piece, or here it all is? I don't know the answer. I don't know which is better.
Marcy, you have your hand up?
Yeah, I just have one more question. What was the thought process, effective communication with the client and others, I'm just was curious as to why that was in there.
I put that in there because I figured that it's, I think the representation will often entail perhaps communication with family members, perhaps witnesses, perhaps opposing counsel. It can just be a variety of folks that could factor into a particular representation. So as opposed to limiting it to, you should only be aware of the communication with the client, but that understanding that communication with others, with folks beyond the client, can impact that particular client's case too. So that was the thought process.
Okay.
And although it seems like we're kind of circling around a potential proposal, I know this was to Carmen's point before. I don't know if you all feel that handling of a particular matter is even necessary. That kind of ties it to, I think I wrote that in because it ties it to a representation to the actual act of lawyering. But it may just be kind of understood to be in there. So one alternative would be to delete that and just to simply say, and I think this is to your point, Judge Hennett, that it's just competency. Competency includes a lawyer's awareness.
I prefer that.
I agree. I think that looks good. Do we need to make a motion?
I'll certainly entertain one.
I think she just made a motion. I think I just seconded it.
There we go.
That sounds good. All right. So any further discussion along those lines? And Brian, we're talking, okay, and we're talking about what you have in red underlined at the bottom there, right?
And no, I think we're talking about this section.
Okay, I got it. Okay.
Is this what we're talking about, everyone? Want to make sure that Matt and Judge Dunstan, I'm going to highlight this with understanding the track changes. We'll clean it up, but the highlighted portion is what the motion was made upon.
That was mine. Too.
Yes. Do you want me to read it real quick?
Yeah.
Yeah, I'll go ahead and read it. So it will say, competency includes a lawyer's awareness of implicit bias and cultural differences relative to the client or anyone involved in the client's matter that might adversely affect the lawyer's representation of the client. This is to ensure understanding of the client's needs, effective communication with the client and others, and adequate representation of the client. Judge, is that your motion, just to clarify?
That's my motion.
I'm sorry to interrupt again. I have a thought though. I think saying the client in that first instance sounds weird. Because, I would say a client at the beginning, just in the first note, just the first reference where after cultural differences. Yeah,
Okay.
relative
To a client.
to a client or anyone involved in a client's matter. And then after that, I think it's appropriate to say the.
Gotcha.
Got it.
All right. I amend my motion to those changes Carmen suggested.
Matt, you accept that?
Second. I accept.
Colin has his hand up.
Just before you, and I hate to fly speak, so this is not what I'm good at, but the word adversely, does that add to it, or is it just, it affects it however it affects it.
Oh.
Good point, Colin. How about that just might affect the lawyer's representation
Yeah.
of the client? I also amend my motion.
There you go. Matt?
Who am I to argue with Colin?
Right?
Or a judge.
He argues with himself.
Yeah, that makes sense. You good with that, Matt? Take it out adversely?
I am.
Okay.
All right, well, then there's a motion and a second
All right.
on the floor.
Any further discussion? All right. All those in favor of the motion that's highlighted and on the screen here, signify by saying aye.
Aye.
All opposed, like sign. All right. Now, I guess we need to decide, do we have any strings attached? Or suggestions that go with it? Like to hold back to send as a package, or to go ahead and go forward with it?
I think that's up to ethics committee, I guess. I don't know if that's really us.
That's probably right.
I'm not on ethics.
We could
but I think
recommend something.
I think that's ethics call on it.
Takia, you?
Yeah, I think so. I think it is going to be up to the ethics committee and what they, because I'm on the ethics committee, decide to do as a whole. I think maybe if we have a recommendation, but I don't have any strong feelings at this point about it other than the ethics committee.
For what it's worth, I might add that based upon the frequency that we send over amendments to the Supreme Court, if the council decides to adopt or approve the CLE requirement in April, that would still not get sent over to the Supreme Court until after the July meeting. So during that quarter, because we only send over rule amendments twice a year to the Supreme Court. So if we publish this for comment in April, we would find ourselves at the July meeting potentially either pulling this back to study comments or moving forward with a recommend or a motion by the council or a vote by the council to adopt, and they would be sent over to the Supreme Court at the same time. Now, I would imagine that we're going to get comments on this, and the traditional route would then be to pull this back to subcommittee so you could take a look at the comments and see if the comments change your opinion in any way. And it would be brought before the council again in October, presumably. So it's, I would say the most likely route, I guess, given the amount of response that we've had, is that these things are going to proceed not necessarily together. I would expect that that they might get separated during these processes. So if there's a recommendation by the subcommittee that they be taken up together, I think we need to flush that out. Matt, I see you have your hand up.
Yeah, I think it comes back to what are the other comments, and again, I'm going to save grievance and defer to ethics committee with the caveat that it is the committee's decision and not David Allen's alone.
All right. That's fair. Duly noted.
Okay. We've got a product now.
All right. Well, I know we were scheduled. Frankly, I can't even recall if we had scheduled this thing for 1 hour or for an hour and a half. But we are probably at the end of our time, and I think this is probably a good place to stop. Or I guess we had it for until 4:30. So good. I have not infringed on your time too much, thankfully. But yeah, I think this may be a good place. We've got a product. We've got a final version of a proposed comment that will go before the ethics committee for their review, and for the recommendation is for publication. And I will certainly keep everyone updated upon any comments we receive on the proposed amendment.
Brian, could you send us around maybe after sometime in the next few days, just a cleaned up copy of that so we can just kind of have it to think about?
Yes, I will do that. And if there's if for whatever reason the cleaned up copy doesn't meet what anybody thought it was, then please do let me know, and perhaps we can schedule another meeting if we need to. We do have time before we hit that April meeting, so we could have another meeting if we really needed to. All right, I will send out that cleaned up copy, and otherwise we will move forward from here. But Brandy, I don't think there's anything else to cover on the agenda unless you wanted to address anything else.
No, I think that's it, unless anybody else has anything.
I just want to thank you, Brandy, and the other committee members.
Oh, absolutely.
For your hard
Thank
work.
Thank you all.
Thanks, everyone.
Yeah, thank
Appreciate
you,
it.
Brandy, for listening to all of us and still keeping us focused. Thank you.
Hey, I appreciate all the input. Thank you so much. And Judge, next time we want to see that baby now.
Yeah. Go enjoy the
Hold on.
Oh, okay.
Hold on. Let me get it where you can see him and not me. Hold
Oh,
on.
that's perfect.
Hold on, because mommy's not as together as she was last time.
Not trying to put you on the spot now.
No. Okay, hold on. Here we go. He's sleeping. Let's see.
But we want to see that baby, don't we?
Mm-hmm.
There we go.
Oh, look at there.
Oh, is she baby?
Man,
Oh,
that is perfect.
oh.
Ryan, you're not supposed to highlight it because I'm still in it.
Well,
Right.
Everybody wants to see Isaiah.
Adorable.
I don't want to make you cry or anything, but he sure looks a lot like Jason to me.
Oh my goodness. I'm gonna tell him he would love that.
You
They
tell
have
him
the
that
same hair.
now.
Well, he has more hair than my dad. So
Okay.
You need to go take a walk. Take him for a walk in this beautiful sunshine.
That's
we already
perfect.
did. We went for an hour. That's why he's worn out.
Yeah.
That's
He got his,
great.
he got his sunlight.
Sweet.
Oh,
He's
Oh,
so
that's
cute.
horrible. All right.
Is
Thank you,
that
guys.
is he
Thank
making a
you.
motion to adjourn?
I think you did.
Adorable.
Yeah,
Here's his motion.
Okay.
Got second unanimous approval.
Yes.
Thank you all.
Goodbye,
Thank
Thank
everybody.
you, everyone. We'll be in touch.
Bye.
Thanks, y'all. All right, bye.